Well, good morning and welcome to the Kelso Report for Friday, March 23rd. I'm your host, Clark Kelso. A lighter day today. The Supreme Court didn't issue any opinions yesterday. We have just a Ninth Circuit case involving immigration and 3 Court of Appeal decisions, one involving CEQA, the other involving negotiable instruments, and our final case involving bail bonds. Let's get started with the Ninth Circuit and an immigration case, a rather technical case, I might say. Now, it's well established that an alien who pled guilty to an aggravated felony prior to the enactment in 1996 of the Illegal Immigration Reform and Immigrant Responsibility Act may still seek a waiver of deportation under Section 212 of the Immigration and Naturalization Act, even though the 1996 Act repealed that option. Existing law holds that that portion of the 1996 Act does not apply retroactively. However, Ninth Circuit authority also exists, which holds that the 1996 Act can apply retroactively to an alien who pleads not guilty and then is subsequently convicted of an aggravated felony. According to those cases, an alien who pleads not guilty cannot demonstrate any reliance on the availability of Section 212C relief. Well, that brings us to yesterday's case, Ping v. Holder, where the Ninth Circuit faced an alien who pled not guilty to a crime involving moral turpitude and then was convicted of that crime. This situation is materially different from an alien charged with an aggravated felony, since both a guilty plea and a conviction for a crime involving moral turpitude forfeits the ability to avoid removability. It's only by securing a not guilty verdict can an alien charged with a crime involving moral turpitude avoid immediate removability. And because of that material difference, the Ninth Circuit held that an alien charged with a crime involving moral turpitude could reasonably have relied upon the availability of Section 212C relief in deciding to plead not guilty. And therefore, the 1996 Act should not apply retroactively to such a case. I think that decision's probably going to hold. I don't think the Supreme Court's going to want to wade into that complex thicket. Now we turn to the California Court of Appeal, first a case involving CEQA. The California Waste Act requires Cal Recycle to prepare and adopt certification regulations for local enforcement agencies. Under the Act, a county's Board of Supervisors may designate a local enforcement agency to inspect, issue permits, and enforce regulations at solid waste landfills. Well, in Marin County, the board designated Marin County Environmental Health Services as the local enforcement agency. Now, over the last 15 years or so, the enforcement agency finally completed and certified an environmental impact report and issued a permit for a solid waste facility. The plaintiffs tried to appeal the certification to the County Board of Supervisors. The board rejected the appeal on the ground that the local enforcement agency had sole power to certify the EIR and issue the permit. The plaintiffs then filed an action in the Superior Court challenging both the board's refusal to accept jurisdiction and challenging the merits of the EIR. The Superior Court held that the board should have accepted jurisdiction and issued a writ directing the board to review the EIR. But the First District on appeal reversed in No Wetlands Landfill Expansion versus County of Marin, where the court held that the regulatory structure of the Waste Act in its interaction with CEQA revealed that approval of a solid waste landfill permit and certification of the EIR for that approval is a power that's vested exclusively in the local enforcement agency. And that agency is a distinct local entity from the county. Accordingly, there is no appeal to the county board, and the plaintiff's proper approach is to challenge the enforcement agency's certification and permit in an action filed directly in the Superior Court. As a result, the First District remanded the case to the Superior Court for consideration of the environmental claim. Next, case involving negotiable instruments. A compromise and release of a workers' comp claim was executed, and the employer sent a $17,000 check to the employee. Unfortunately, the check was sent to the wrong address. Nevertheless, the check was negotiated with a forged endorsement at a check cashing service and was paid by the employer's bank. When the employer failed to remit a second check to the employee sought assistance from the Workers' Compensation Appeals Board. The board found in the employee's favor and the employer appealed. The 2nd District yesterday affirmed in Barrett Business Services versus WCAB. The case was easily resolved under Section 3420, Subdivision A, 3420, Subdivision A, of the California Uniform Commercial Code, which provides in relevant part that an action for conversion of an instrument may not be brought by a payee or endorsee who did not receive delivery of the instrument, either directly or through delivery to an agent or a co-payee. A comment to this section explains that until the payee actually receives delivery of a check, the payee has no interest in the check, and the payor's debt continues to exist even after a thief cashes the check under a forged endorsement. In other words, it is the delivery of the check and not the mailing that determines who bears the risk of theft and negotiation pursuant to a forged endorsement. Finally, a case involving bail bonds. The intricacies of bail bond law were before the 5th District in People v. International Fidelity Insurance Company, where the surety on a bail bond appealed an order denying its motion to discharge a forfeiture and to exonerate its bond. The 5th District agreed with the surety and reversed. The defendant here had been arrested on a charge and appeared in court where a bond was posted in the amount of $35,000 for the release of the defendant from custody. About 1 year later, at a court appearance where the defendant was present, a deputy district attorney informed the court that the defendant had outstanding warrants in 4 other driving under the influence cases, and requested that the defendant be remanded to custody. So the trial court obliged and remanded the defendant to custody, and then stated, quote, "Bail is going to be set at this time at $100,000, close quote. Subsequently, the court stated, quote, "He does have a bail bond in this matter. How much is the bail bond? $35,000. I'll allow the $35,000 to remain. The additional amount is $65,000, close quote. The deputy district attorney responded, "That's fine, thank you, Your Honor," and the proceedings were concluded. A local bail bondsman then issued a bond in the amount of $65,000 backed by the surety. When the defendant failed to appear, the prosecution moved to forfeit the bond. Well, unfortunately for the prosecution, the 5th District explained that when the trial court remanded the defendant to custody, the $35,000 bond was exonerated as a matter of law immediately. So when the court then set bail at $100,000, and then the sheriff released the defendant on the posting of only a $65,000 bond, the result was that the $65,000 bond was unlawful and void, because it did not conform to the court's order that bail be set at $100,000. So in these circumstances, the surety's motion to vacate the forfeiture should have been granted. Win-1 for the surety. Well, that's it for today's Kelso Report. Have a great day in the law and a good weekend.